Hi everyone, and thank you for joining us. Welcome to Future Histories. Let's begin by acknowledging the traditional custodians of the lands in which we meet and their elders past, present and emerging. For me, here in Sydney, Australia, it is the Gadigal people of the Eora Nation which I would like to acknowledge. And an especially warm welcome to First Nations people joining us today. For those of you joining us live or on demand for the first time, the Australian Society for the Computers and Law is a multidisciplinary think tank with a proud 40-year history. Our patron is the Honourable Michael Kirby. We promote learned discussion, education and advocacy on critical issues at the intersection of technology, law and society. We're a registered Australian charity and we actively support the UN Sustainability Development Goals. The 3 goals that we're supporting today are those 9, 10 and 16. We are so privileged to be joined by Lizzie O'Shea and Carmel Lee. They will be exploring how social movements can shape a sustainable, peaceful, prosperous digital future, but not being blind to the risks and the problems that may arise, and other themes within Lizzie's latest book called Future Histories, and there's the full title on the screen for you now. I urge you to read the book, it's fabulous. One of my favourite quotes in the book is, technology is presented as a force of nature, but technology is made by human hands. It's a sort of a two-edged sword for me reading that comment, because it's empowering to say that we can do something about things, but then it sort of comes with the user warning. Do we trust the people behind technology and how can we make them accountable? So to help us navigate these issues and themes and to lead the discussion, let me introduce you to, and I came up with this term just now, learned conversationalist Carmel Lee, who has kindly agreed to accept our invitation. In fact, both speakers have kindly agreed to accept our invitation to speak, and that both are speaking in their personal capacity. Now, it's important to say that because they both have exemplary careers and lead in many different ways. So to introduce Carmel is a barrister at Greenway Chambers here in Sydney, specialising in commercial law, equity, conflict of laws and public inquiries, public interest law, strategic public interest litigation and pro bono matters. And I know this just by looking at your case history there, Carmel, so well done and please keep up your good work. Carmel is a member of the New South Wales Bar Association Human Rights Committee and has held many distinguished roles, including as the Deputy Registrar of the New South Wales Supreme Court and the Court of Criminal Appeal. Also as tipstaff for several leading judges in the Supreme Court of New South Wales and the Court of Appeal. So Carmel, now over to you to introduce Lizzie, and thank you so much for running the session today.
Thank you, Marina. It gives me great pleasure to introduce Lizzie O'Shea to the audience. In fact, I fought Marina for this privilege to introduce Lizzie to you all today. Lizzie is a lawyer, a writer and a broadcaster. She's written for New York Times, The Guardian and the Sydney Morning Herald, amongst other publications. She's the founder and board member of Digital Rights Watch. If you haven't looked at their website and read a bit about them, I encourage you to do so. That's an organisation that advocates for human rights online. She also sits on the board for Blueprint for Free Speech and the Alliance for Gambling Reform. Her book, which we're talking about tonight, my own very tabbed and underlined and highlighted copy and much thumbed, is called Future Histories. It looks at social movements and theorists from history and applies them to debates that we have about technology today. It was shortlisted for the Premier's Literary Award. If you haven't already got a copy of it or read it, I highly encourage you to do so. I thoroughly enjoyed this book. Over to you, Lizzie.
Great. Thank you so much. Thank you so much to Marina for organising this and for Carmel being such a generous and engaged co-collaborator on this conversation. It's a real joy to work with people on these topics who are interested, engaged and want to make the world a better place and think through the human rights implications of these kinds of topics. I thought what I'd do is just talk a little bit about how I came to write the book and what the scene was at the time I was doing it, and perhaps also reflect a little bit as well about where we are in our present moment, because a lot's changed in that time. And then I'm really keen to talk to you and obviously Carmel as well about any questions that you might have. So when I first started writing this book, It really felt like we were in an age that was saturated in pessimism, in which phenomena like climate change threaten the lives of millions of people, inequality grows unchecked, and right-wing populism peddled fear and bigotry. The appetite for radical social transformation to address these trends is often lacking, but there are real notable exceptions to that. Progressive and left-wing ideas are still popular. Alternatives to rapacious and growth-centric capitalism are beginning to look not just promising, but even necessary. And radical proposals for redistribution of wealth and universal social welfare programs have proven compelling in lots of jurisdictions around the world. And the developments in technology have really highlighted how some of these changes might come about, how human ingenuity and cooperation has the potential to overcome some of the most profound challenges that we face. But unfortunately, what technology is doing is not necessarily what we want. It's in fact doing something almost entirely different. Digital technology, it's in our homes, it's in our pockets, it's sometimes even under our skin. It's invaded our physical and our psychological spaces, often without our consent and sometimes without us even knowing. Technology is treated, as Marina referenced before, as a force of nature, without an agenda, that it's inevitable and stoppable, that it simply cannot be resisted. Society is treated as an object that technology does things to, rather than a collective of people who have agency and a desire to shape their own future. So the tech we have is not the tech we want. It's the tech of the wealthy, of billionaires rather than billions. And my fear and my hope, and really the key motivation behind writing this book, is that we are not making use of the potential of the digital revolution, but it's within our grasp to change that. And the question becomes, how do we fix this? And I figure that for navigating these particular problems, history can be a very powerful guide. To reclaim a more democratic future, we need to stop looking forward, actually, and start looking backwards. And we have examples from history that can illustrate how people organising and collaborating together can hold power accountable as consumers, as voters, as advocates, and as workers. And this is our chance, this is our moment to take the lessons from our past and apply them to our present in fresh ways. So that's the purpose of my book, to offer some analysis of history, whether it's the history of an idea or the history of a social movement or the history of network computing itself, to allow us to make claims about how the future could look and how it can, in fact, be different. So we need to remember the great historian Melvin Cransberg's laws of technology, that technology is neither inherently good nor bad, but nor is it neutral. We need to remember that as billion-dollar companies claim that they're bringing progress, when they're really actually bringing immiseration and unpredictable, unstable work for billions of people. So if we want to understand, for example, the history of or the existence of the modern surveillance state, then we might want to look backwards at the history of the first modern police force, which is what I try to do in my book. That I argue we should never forget the Paris Commune, which argued for individual liberty, liberty of conscience and liberty of labour, because those ideas, notwithstanding that they're 150 years old, are actually far more forward-thinking than the freedom on offer from people we hold up as visionaries today, like Elon Musk and Jeff Bezos, who can only imagine going to Mars and building another Amazon fulfillment centre there, rather than building a genuinely democratic society. So I think we can learn from someone like Ada Lovelace, one of my favourite historical figures, who bridged the impossible gap between poetry and philosophy as the first ever computer programmer. But she did so in the wrong gender, and so it took the world a full century to catch up with her. So the idea of this book is really to serve two audiences. It provides an introduction to some of the key debates generated by the development of digital technology, for those who've perhaps been hesitant or even reluctant to meaningfully engage with these topics. But it also provides an introduction to some political traditions for those who perhaps are already immersed in the world of technology. So I would claim that if you have ideas about history, then you probably have ideas about how technology should be organised and developed. And equally, if you have thoughts about technology, you might find that your criticisms of it have precedents in our past that are both rich and inspiring. So this book really attempts to build a bridge between those two audiences in the hope that cross-collaboration between technologists, activists, makers and critical thinkers will help us define a collective future in the digital revolution that is more democratic. That's the context in which I started writing this book in 2016, 17 and 18. But of course, since then, the world has changed remarkably. And it would be a mistake, I think, not to take the opportunity to talk a little bit about the present problems we face. When I was first thinking about these ideas, cracks were starting to emerge in the shiny business model of Silicon Valley. People were beginning to notice how the promise of the digital revolution was not being realised in all sorts of profound ways. And this really took form in the election of Donald Trump and the Brexit referendum, both quite surprising results, which forced social media companies in particular to reflect upon the effects of their business model. There was a sense that technology capitalism depended on predatory business practices, incentivised exploitative models of work and undermined democratic institutions. And people were realising that these governments cooperated, cooperated with governments to surveil citizens. The experience of being online was an experience of being watched, essentially through a one-way mirror. But just a few years later, the question is not whether the industry needs to change, but how. Discussions about breaking up big tech are now commonplace. Data extractive technology projects are often met with significant criticism. The flexibility of the gig economy has clearly become a millstone around the necks of the most vulnerable workers in society. And finally, that one-way mirror is starting to reveal its secrets, and we're catching a glimpse of how power functions in the digital age. Now, these, I think, are perhaps more crucial times than ever for figuring out where we've been so that we can forge a path to a more democratic tomorrow. That we do really need context, perspective and history if we're going to make a difference, and we're going to have technology that can tackle the profound problems that we face. So, of course, as we speak now, some of these tendencies have in fact accelerated with the pandemic. We're settling now into a new normal. And if these fractures were emerging, say, in 2016, COVID has in fact acted like an acid wash. It's seeped into our daily lives, it's stripped them back to their fundamentals, and it's corroded and deepened the fissures that predated this moment. These particular years have been years of misery and death for many, and it's really painful to see the consequences of mismanagement by those in power visited on everyday people in such visceral ways. But in respect of technology, the ongoing crisis created by the pandemic also creates opportunities. And this is particularly true for those who are interested in rerouting our society in a more democratic direction. The internet is clearly more important to our lives than ever before, and its brilliance as a creation of human ingenuity is on full display in the age of social distancing, where life would simply not be the same or would not be able to be in connection and build communities online if we didn't have the internet that helps us get through this terrible period. So it's more important than ever that we find ways to protect its openness and its accessibility, that we encourage it to be considered a universal right, and that we find ways to promote the collective creativity that underpinned its development. But what I would say as well, of course, is that those who hold power have not been idle during this period either. They're already seeking to encode permanence into various aspects of this state of exception to shore up status or profits, whatever it is, for themselves. Technological solutions are cheaper and appear more reliable and neutral than other more participatory solutions to social problems. And this is a trick that's been used by those who hold power, particularly in governments. Technology will continue to play a role in this crisis and its aftermath, and there's lots that it could do that is wonderful. But we have to be very careful about thinking about who is making decisions about how technology is built and used and why. So at this moment when so much hangs in the balance, when the world is contending with the vast changes wrought by the pandemic and imagining what more changes might come with the spectre of climate change, we have an opportunity to argue for technology that is open, accountable and democratic, that is designed in ways that are decentralised, that rely on open source principles. We can highlight the importance of transparency and accountability as integral parts of the design process, rather than just allow these concepts to be an afterthought, patched on later when the opportunity to gain public trust has already been squandered. We also need to learn to say no to technology if we cannot offer significant protections. Maybe, for example, we need a moratorium on government and corporate development of facial recognition technology, a conclusion that in fact several major cities around the world and companies have drawn in the United States, and we at Digital Rights Watch, for example, advocate for here. So maybe we need to ask these questions about technology more often. If it cannot be built in a way that protects the most vulnerable, that empowers the disenfranchised, should it be built at all? There's a crack in everything, Leonard Cohen liked to remind us, and that is how the light gets in. And these last few years have shown that the cracks in the digital revolution are emerging, and it's shed light on the problems that it has created. And our job is to use that light to navigate towards a more democratic digital tomorrow.
Thank you, Lizzie. I think you touched on a couple of points that I might springboard from. One of the things that you touched on was we've seen significant developments in the world in the last couple of years, but there's also a potential there for change. To go back to your book, in chapter 4 of your book, you looked at the flaws of the Ford Pinto, and you used that as an analogy for ethical considerations in design by various corporations. And that sort of leads into issues perhaps of corporate social responsibility and regulation if those fail. And then in chapter 5 of your book, you discussed the Paris Commune. And you looked at worker-led change that came through the Paris Commune, but you also looked at groups such as Craigslist, for example, which was a communal or collective experience on the internet, as opposed, in contrast to the large corporations such as Facebook. So my question is, assuming that change is needed from your opening comments, what's the best way to achieve that change? Is it a top-down approach or is it a bottom-up approach?
Yeah, it's a really interesting question. I'm glad you raised the Ford Pinto, because I always like talking about the Ford Pinto with legal audiences. It was taught to me in law school. I hope that that's true for law students still today. But the example, of course, is a car that was designed by Ford. It was designed to appeal to the cheap end of the market, and they faced a difficult decision in the design process about whether to, they knew there was a fault in the design, where the fuel tank was right near the bumper and it was liable to, inclined to ignite if bumped just gently from behind. Now, they knew that and could have inserted a plastic buffer between the fuel tank and the bumper bar that would have prevented a lot of these fires for about $1.25. And they elected not to, because the delays caused to their production would lose the market opportunity that could be exploited by them to sell these cars. And of course, the result was that hundreds, possibly thousands of people died in the most appalling circumstances, burnt to death in their vehicles, completely unnecessarily. And my argument there is that that's a design question, but it's what happens when design principles are beholden to the bottom line, when profit is more important than safe design principles. Because what the company had done was done a cost-benefit analysis of having to pay out compensation to people and figured it would do better by rushing through the process. But of course, people are appalled that companies behave like that. One of the things that I think is interesting about this little episode is that lawyers played a key role in bringing about change. So cars were traditionally largely unregulated from a safety perspective, but in this period, mid-century last year, there are a lot of lawyers who are actively bringing claims for people who are injured in this way and others. And those kinds of court cases highlighted the problems with the design process that's beholden to a bottom line and caused regulators to step in who were reluctant to otherwise do so. So in answer to your question, I think we can't rely on regulators or elected politicians alone. We have to force them to work for us. And there's lots of different ways we can do that. Litigating is one of them, and I think it's a really important one. And I know, Carmel, you've done a lot of great work in this space to achieve that goal. Movements of people who advocate on behalf of each other to make sure that power that's exercised in society isn't done carelessly with respect to people's rights and people's safety. You mentioned the Paris Commune as well, and I love talking about the Paris Commune because I think it's a really interesting little period in history. And it is, when you go back and read the documents, even though this is the late 19th century, some of the things they were talking about are still so revolutionary, even by modern terms, that it still makes me excited to think about. And I do think they also applied a bottom-up approach to basic things like how you would make decisions about when people would work. So they cancelled nighttime work in Paris in the period. They abolished rents for a period. They had collective organisations that determined what kind of artwork would be on display. So it was popularly organised instead of it being the subject of the academy to determine what is the appropriate art and what isn't. And these kind of bottom-up structures, when you start to experiment with them, you can see all aspects of daily life that might be shaped differently if we gave people the opportunity to have a say. And I sort of think surely the internet is one of the great tools of democratic participation. Of course, people don't always engage online well, and that's a separate question. But in terms of how we can access people to participate in public life and help make decisions and do so collectively, it's surely we've got a greater opportunity, more so than ever in human history, to be able to facilitate that through the internet. And that's really what I wanted to revive, that idea that alternative ways of deciding what's possible and what's good about society and which direction we can take can be returned to people, and using the capacity of network technology to do that.
Sarah, down more specifically, we've seen that there have been significant protests by workers at Amazon and most recently by NBN workers in Australia about the use of technology to regulate and monitor them at work. What's the best way to bring about changes in workplaces?
Yeah, I think it's been a really interesting phenomenon. So one of my arguments in the book is we need to revive the 8-hour day movement as one of the most successful social movements in human history. The 8-hour day movement didn't start as the 8-hour day movement. It actually started as a movement to stop child and labour in factories. It gradually expanded to the 12-hour day movement, then the 10-hour day movement, and we eventually got to the 8-hour day movement. And call out to my home city of Melbourne, one of the first strikes that took place to advocate for this successfully was at Melbourne Law School. And if you went there, you may have seen the sandstone plaque that commemorated this. But my point there is we need to reclaim that time. I think we need unions to revive the campaign for an 8-hour day so that people who work, and particularly those who work from home, aren't constantly and relentlessly assaulted by work. But one of the interesting things about, I suppose, the recent controversy around Amazon and unionising their workforce, I think, is it shows you that these big companies, despite being very modern, are still pretty terrified of what they would classify as a 19th century institution, the union. And Amazon will deploy its full potential to try and stop this. It's not just that they campaigned against it, it's that they use data about their workforce. They surveil their workforce all the time, and then they use that data to try and track and manage and monitor potential outbreaks of unionisation. And they do things like prohibit certain kinds of congregations or conversations among workers. So they make use of the fact that the workplace is more surveilled than ever. And so I think even if you do clock on and clock off, I think we have a right to work not under constant scrutiny by our bosses, not just because it's inhumane in terms of doing your work, but also it empowers them to try and stop agitation and organisation. And this is, in fact, what they consider to be quite a serious threat to their business model. It's not just Amazon. I don't want to just dump on them. People may have seen that Uber also sponsored a proposition in California at the recent presidential election, such that workers who, or drivers on their platform, should not be classified as workers. And again, I think here's a very modern company, very, very concerned about labour being a source of their potential value, I suppose, or certainly a thorn in their side if organised and demanding of their rights. And so, yeah, I think we've got a lot of scope for unions to update their organising activities to start to make central to their claims some of these arguments about limiting surveillance in the workplace, limiting your capacity to have to work outside of particular hours so that we can work less. Because to my mind, it seems like a tragedy that this great promise of automation has actually delivered longer working hours across many parts of the world with greater wealth inequality as a result. So something needs to change there. And I think how we approach what is valuable in society, including your right to work, that your time and your freedom from surveillance is quite important, we might start to see an improvement in that particular position.
How do we stop that trend, perhaps? You've talked in your book, one of your quotes that I love from your book is that from a data scientist, Cathy O'Neill, who said that the privilege are processed more by people, the masses by machines. We can see the way that automation has come in and monitors people at work, but we can also see how that extends into the home life as well. We've seen more people working from home during COVID. We've seen the creep of technology in the work day into the home space. We've seen the creep of work hours through constantly being able to access emails on smart devices, etc. How do we stop that creep? If we've had the 8-hour workday previously, how do we go back to that ideal?
Yeah, well, if you look at something like something like Microsoft is what I meant to say. Microsoft has a suite of products now available to managers to be able to review exactly what their workers are doing if they use Microsoft products. And that to me is pretty alarming, being surveilled at all times. That's one of the big potential opportunities for those who employ people to make use of technology to properly or to more aggressively manage workers. And I think it makes work a much more miserable place. So I think we should talk about prohibiting the use of that kind of technology in the workplace and putting limits on it and expectations of rights. We should start thinking about putting this in minimum employment standards and the like, the right to know what kind of data is being collected about you and what it's being used for. This is actually a subject, the New South Wales government has had an inquiry into surveillance in the workplace, and often when we think about that, we might think about, cameras and the like, but I think we also need to think about it in terms of software and white-collar workers. And the United Workers Union provided a great submission on this, which has got lots of different proposals, but they do talk about using data in ways to improve the workforce and improve the kind of work people do and to build efficiency, but to have it in a regulated way so that people know how this might work, to offer feedback and the like. And they talk about data trusts in that respect. And I think there's a lot of scope in that kind of potential proposal, and it's worth exploring. At the moment, what we have is just the gradual creep of technology into all facets of our life. You're now working from home, you might be working from your bedroom, and your boss gets to see what you're doing at all times in there. It just seems so deeply unfair. So I think we do need to find ways to incorporate into workplace legislation limits on what employers can do, and that's a perfectly reasonable request.
That probably leads neatly into what I wanted to bring up next, and that's is to do with privacy. We've seen some very interesting cases coming out, particularly from the UK and from the EU Court of Human Rights as well in these issues, from Europe, generally. Most of those have been based on Article 8 of the European Convention, which briefly talks about the exercise of the right to respect for a private and family life, except in accordance with law and as necessary from a democratic society for the interests of national security, public safety, economic well-being of the country, etc. We see that in August last year in the UK, there was a Court of Appeal decision which was to do with the use of technology, which was based on facial recognition, and whether or not that was impeded on a person's right to privacy, and the court finding that did impede on a person's right to privacy. Earlier that year, we found that the Hay District Court looked at an automated system for detecting welfare fraud as well, and whether based on the likelihood of a particular person possibly engaging in tax fraud and a risk prediction system, depending on various data that had been collected about that person, and again a finding that interfered with their rights to privacy as well. And again, from the year before, in 2019, the European Court of Human Rights, a case about an applicant who had been involved in anti-war demonstrations, that they asked the police to disclose the records that were held about that particular individual. There were 66 records that claimed that they existed on extremism database, and that they claimed that their rights had been affected under Article 8 because of a lack of respect for their private life, because of this loosely defined notion of what domestic extremism was, that needed to be rethought of. Some commonalities in this is a use of discretion by the person to apply this technology against a particular individual, and the encroachment on a private life. Can you comment on whether similar litigation approaches would work in Australia, and why would they or why wouldn't they?
Yeah, it's a really, really interesting question, I think, because apart from the concept of privacy, it's hard to sort of conceive of these topics that you just described that are all, deal with the right to privacy, sharing commonalities, which I think gives you pause for thought about how diverse that right is, or what it's protecting is such a diverse thing. What I mean by that is, in Australia, we don't obviously have a Bill of Rights, but we don't, there's been a long discussion about the potential for a statutory tort for serious invasions of privacy. And one of the limits in not having something like that is their courts obviously can't interpret the right to privacy. They can't offer updated ideas of what public expectations of privacy are. And so really what we have is, companies, governments just engaging in really largely unregulated behaviour, how they use their data. They may be compliant in formal terms, but there's often an enormous gulf between people's expectation of privacy and what is actually enforced or complied with in both the private sector and government spaces. And that creates all sorts of problems. That's bad for us as a society, I think, and we need to fix it. Now, I would sort of classify the concept of privacy, therefore, I think is a really complex and detailed one. And one of the things that irks me about this space is that when we talk about privacy, it's often thought of as closing yourself off from the world, whereas in fact, I think it's much more sophisticated than that. It's also about being able to collaborate with others online, being able to choose to be part of a group on your own terms without being watched by someone. And to that extent, I think there's probably two main ways to think about privacy. The first is as against the state, and you talk about the activists there being targeted, that the state might have an interest in knowing your name and address and finding tools to identify you at a protest. We know in Australia, for example, that police use Stingray technology to intercept cell phone communications. We know they use, in Melbourne, for example, there's 64 cameras that are used regularly to surveil people, sometimes for public safety purposes, but also in the context of political demonstration. And being able to identify that with your name and address is obviously troubling, and it can impose upon freedom of assembly, the right to protest, which are foundational to democracy. But there's also another component of privacy, which is you're engaging in online spaces and various companies collect data about you. They don't really care what your name and address is. They don't really want to bring home anything to you particularly or do anything with that information. They want to know what cohorts you belong to, because then they can provide nuanced information that becomes audiences for advertising. And that's a different kind of harm. I don't think we can assume that just because your name and address might be off that particular bit of information, that therefore no harm is done, because it does degrade our experience of online life when there's constant buying and selling of your data. But it also does push you in a particular direction. You become, other writers have talked about a digital doppelganger, a shadow version of yourself that wanders around the internet, and companies make assumptions about you. You might not be able to access certain kinds of services. You won't be advertised certain kinds of things, sometimes on quite terrible bases, discriminatory bases. And it's very difficult to unpick that and know what's going on. And it does limit our autonomy, our capacity to engage in online life without being corralled into a particular way of behaving. And I think that is the other component of privacy that we need to think about in the context of this right. And I think in the age of the data economy, this is something where judges could meaningfully intervene and start to discuss. So even if you haven't personally experienced harm associated with your name and address being published or being given to someone that you don't want, there is still harm done by your data being packaged up and shared and sold. To give you an example, the National Australia Bank, for example, was revealed to be de-identifying data and then selling it to a data broker or giving it to a data broker who then sold it on to Sportsbet. And Sportsbet spends $500 million on digital advertising on an annual basis. Now, I don't think anybody who gave their information to NAB would have thought that's where it would end up. And NAB argues, I'm not sure that it put out a public statement, but it would be able to say that it was formally compliant with the privacy laws that exist. But of course, when this was exposed, they immediately stopped doing it. And that's because it's gross. People don't want this to happen in our environment. They don't want to have information shared for one purpose end up being used in an exploitative or predatory way. And I think we need to make sure our laws match that. It's really interesting to see all the intricate and different ways in which the right to privacy takes expression. We're at a disadvantage when we don't have the capacity to raise these kinds of concerns and fully expose the practices of the data economy, but also then set in place what are community expectations and how we can enforce not just the right to be left alone, but the right to participate autonomously in public life.
Could change the Privacy Act assist in that as well? I know that it's, I think the last update to the Privacy Act was in the early 2000s from memory. Would that assist in this area?
Yeah, it's a really interesting question. People may know that the Privacy Act is currently under review. It's with the Attorney General's Department. This was one of the recommendations of the ACCC in their Digital Platforms Inquiry report. They suggested that now is the time for that. I think there's a lot of things in the Privacy Act that need to change. There's obvious ones like political parties are excluded from its application, which I don't think anybody thinks is probably sensible, but are very difficult to get politicians to legislate against their own interests. So that's going to be a challenge, I reckon. But there are lots of other ones. So the definition of personal information, I think, could be expanded. It's too narrowly drafted. I mean, what I mentioned before, de-identification, I think, is really important. At the moment, or the NAB example I was using before, if you take data and de-identify it, you can then share it without somebody's consent in many circumstances. And there's almost no definition of what de-identification involves. And we know from lots of examples that de-identification is actually much more difficult than you might think. There was a recent, or a few years ago, Medicare released data sets, like 10% of Medicare rebate or Medicare entries and some 10% of PVS from a particular period randomly selected. So a data set for analysts to use, but instead of giving it to analysts or researchers one by one, they put it online. And, a friendly hacker, a university academic, actually found a way to reverse engineer that process and identify people from that data set. And that's very sensitive information. I'm not sure Medicare intended, of course they didn't intend for the de-identification to be reversed, but they're a sophisticated institution that should have known the potential difficulties with that. It's very disappointing that it happens. And once that data's out there, it's out there. Mm-hmm. So I think defining what is required in de-identification circumstances would probably limit the careless sharing of data, the monetization of data in this way. You could make it a purposive limitation, for example, but then also putting in place things like the requirement to notify people if their data is at risk of being re-identified, I should say. The requirement to pay penalties. I mean, I am a litigator, so I would like to think about how you can wedge people to do the right thing for fear of litigation. There's lots of things like that, I think, that would really transform the current horse trading that goes on with data, where people share things for one purpose and ends up being used for something altogether different, and that shouldn't be permitted. The last thing I'll say on that as well, if I could, is I think the government could do better at being an upstanding citizen in this place, in this space. I talked about Medicare there, for example, but the other example that comes to mind is actually Clearview Ai. People might know about this company, but it was started by an Australian. But essentially, it built a facial recognition database by scraping photos from Facebook and feeding them into the algorithm to teach the algorithm to recognise faces. We know that federal police have actually been using this, and that to me is pretty alarming, not least because there's very few rules around facial recognition, but also because we know that was an inappropriate use of those people's data. They put their photos on Facebook for one reason. They didn't expect that it would be misused in a facial recognition database. And I think if government continues to kind of allow this bad behaviour to go on, we're not going to get any better behaviour from the private sector, and it's up to them to make sure they're going above and beyond what their obligations are to individuals.
Could a Bill of Human Rights assist in this area?
I'm curious to know what you think about this, Carmel. I mean, absolutely, I think so. I think we stand alone, really, now as a liberal democracy without one. And it means that our law is developing in a way that is different to our counterparts, and it's a problem. I don't think we can continue to lag behind in this way. I mean, I'm curious to know what you think. I think it's critically important. Yeah, I mean, the one more thing I'll say about that is we participate in the Five Eyes Intelligence Sharing Alliance, so the Anglophone countries, Canada, United States, UK, New Zealand and Australia. And it's telling, in my view, that some of the more experimental legislation in relation to national security has been passed in Australia, where we as a country do not have rights protections in every other country in the Five Eyes does. And so we become the testing ground for really bad laws, and that's a terrible thing. So I think it's a source of shame, and we absolutely need to fix it. I'm curious to know what you think, though, Carmel.
Thank you. It is quite remarkable, isn't it? I mean, I think we know that some states around Australia, the ACT, Victoria, Queensland, have bills of rights within their state legislation. We know that we don't have one nationally in Australia, which presumably a national bill of rights would greatly assist in this area, but a state bill of rights might be a start in that field, particularly for New South Wales. So that would be one way of protecting that. I think it's interesting you talk about the lack of protection for the Five Eyes. The lack of protection that we have compared to other countries. I think the examples that I used before, we see a lot of litigation happening in Europe to protect various rights, but of course in those countries that have the EU Court of Human Rights, they have various bills of rights, they have a English constitutional legal history that defends and protects those rights as well. And I know that Australia, although we have ratified the ICCPR, we haven't brought that into domestic law in Australia as well. So there's limited domestic protections of the rights under the International Covenant of Civil and Political Rights as well. So my background is more in that sort of human rights sort of field, and I think that certainly one thing that strikes me about your book is that you look at, I mean, the entire title of your book is a symbol of this, that you sort of call it future histories. We look to the past to look at how we're going to solve problems going into the future. We've looked at a number of rights issues in the past, labour rights and other such issues. Technology will change, but basic rights can be extrapolated out. The medium in which those rights are being abused might change in different ways. You may have more invasive technology in your home. The 8-hour workday might change because you're looking at your smartphone more often, or there's more the work comes into the home a lot more, but the basic rights in terms of labour, privacy, freedom of expression, etc., I think is still the same as well. And those rights we've seen in test litigation overseas. Certainly we have new novel forms of technology, facial recognition, predictive technology in relation to whether someone might commit a crime or not, but we go back to those original rights in relation to privacy or innocence until proven guilty, etc. as well. So I think that's quite interesting. So I think that's quite fascinating in that area.
Yeah, I mean, I take Andrew's point in the chat that there are limits to it. I don't think it's a total solution to the problem that we face, because even the best laws can be abused, or there's always technology that comes that is arguably unanticipated by some of these legislative frameworks or rights frameworks. But I think it's kind of now a baseline requirement that we ought not be without, I suppose is how I would describe it, a necessary but insufficient condition towards a democratic society, I suppose. And that's my perspective where I come at it from, because if you think about something like the COVID Safe app, or other contact tracing stuff, there's a big push in those moments of crisis to make use of technology in invasive ways, and human rights ideas are not without tools to navigate those moments. We talk about what's necessary and proportionate, and in the absence of that, we're kind of left to politics and the political grandstanding of politicians to talk about the dramatics of the pandemic, to also talk in foolish ways about the potential of technology. I mean, Scott Morrison talked about the COVID Safe app being like sunscreen, as though it protected you from actually contracting the virus. So really irresponsible communications when it comes to both technology and the urgency of our particular moment. And we would get better technical products. We get better technology policy from government, I think, if they were forced to think these things through before they implemented them. You'd also build more public trust in these projects and get better engagement, and you'd actually get better outcomes. So it's not even just to address harms after the event, it's also to create space within decision-making moments in the development of technology that give designers, engineers, the capacity to question things, and then, avoid the political, thunder and lightning that comes, which justifies a particular set of interests. Often, I think, to conceal their own incompetence. So, that's my primary motivation, why I think that kind of language, framework, understanding can be really powerful in those moments of crisis to stop the worst limitations of the worst excesses of politicians.
Absolutely. I want to open the floor up for questions from the audience. If anyone would like to ask a question, if you can put into the chat screen, and then I can ask Lizzie that question on your behalf. Lizzie, whilst our audience is thinking of their questions, I might go to a final question from me, and that is, why do you think that Australia is being watched by the rest of the world in relation to the new legislation they brought in? I'm thinking particularly the Facebook the standoff between Facebook and the Australian federal government last year, and what is some novel litigation that might be watched by other countries around the world?
Yeah, it's a really interesting question, I think, because, one of the reasons I think is we don't have a rights framework, but a symptom perhaps of that or a consequence of that is we do have relatively active competition and consumer regulator. The ACCC has been active in this space, is looked to by other countries in this space as being an organisation that's keen to address the power of big tech and do something about it for consumers and the like. So I think the report and then the media code, which was a proposal that came out of the ACCC's inquiry into digital platforms, was one obvious example of that. I mean, I get a little bit worried sometimes about that because it's sort of like, because we don't have proper privacy rights or privacy laws, the ACCC kind of steps in and challenges the power of big tech from that perspective. There's some utility in it, but I think not all of these problems are consumer or competition problems, and we can start to see the limitations of that. There's currently an inquiry into ad tech going on. The media bargaining code is also an example of this, but ad tech going on about how we can not have monopolisation in the delivery of ad tech. And I don't, that's, I guess, a noble aim to level the playing field amongst ad tech providers. But I'm also just like I don't like the whole industry, and I think it's got a lot of really insidious consequences that we ought to examine. And so I'm not really interested in making the market work better. I'm actually interested in people having rights about their information and, and right to know what's known about them, for example, which is not a competition and consumer lens necessarily. And I think the bargaining code is a similar example. The aim of that was to level the playing field between media companies and tech platforms, whereas in fact who was left out of that kind of conversation were users and consumers who have rights. And actually what that media bargaining code does, I mean, I think that's, I can talk about that endlessly. I think that we do need to do something about the production of quality news, but that media bargaining code preserved that system of monetization of people's data, and it allowed information to flow between those platforms and media companies about users in a way that pitted them as having an alliance as against users. And that to me was disappointing, because I think if we're going to improve online spaces, we need to kind of break that business model. And we need to address the problem of the lack of quality news, but not necessarily in that way. So that's one, I think, reason why Australia is of interest, because we have an active competition and consumer regulator. But I also think we should take that with a bit of caution, because I think sometimes that doesn't always get the outcomes that we might necessarily want if we're interested in human rights.
Excellent. We've had some practice questions come through. Let's start with one of the early ones that have come through, and that is, do you think that democracy is at risk from new technologies?
Yeah, I absolutely do. I think it's part of a functioning democracy is to have common ideas of truth or common ideas of what values might be, and the experience of being in an atomised space in our social engagements online mitigates against that. So I think the business model of social media has put democracy at risk, I think, in ways that are really profound. I think it will ultimately survive, but I don't think it's alarmist to say that. And I think extremism that is promoted by these business models is an enormous problem. I would just throw into the mix that, Lauren Southern, who's an alt-right YouTuber, she's now renounced her alt-rightism, and she's found a spot on Sky News After Dark, I think, which is kind of telling. But, a New York Times article revealed that a third of the traffic to her YouTube videos came from the algorithm making recommendations to users. So this polarization of politics, it's not organic. It's not an inherent quality of human society. It is also being prompted and encouraged by the platforms that we engage in and how they're designed. And that's an enormous problem for building those ideas of common values, of having a sense of truth, of a public space in which everyone can participate. I think there's other ways in which this happens as well, and I'll just throw one more into the mix. But I'm a big one for watching the border industrial complex, how border policing and the policing of migrants and the use of surveillance technology is going to impinge on our democracy, because ultimately that is the place, I think, where a lot of experimentation is happening by technology companies, the militarisation of borders, the collection of data, the invasive way in which we track migrants and how they move, because ultimately I think that will be used on us. So building that infrastructure, and I think we can always look to the border if we want to see the cutting and leading edge of that. I think that's also potentially going to be visited upon citizens in a democracy in really regressive ways.
Excellent, thank you. I've got another question from Andrew. I think I've understood it, but if I haven't, you can feel free to correct me in the chat. Andrew asked, how much do you think that Australian and New Zealand people's rights are essentially dependent on companies' interests in the country's privacy or data laws being judged adequate by the EU? Now, what I assume is meant by that is you may have an Australian company who's operating, but then that product or that particular software might go to the EU and it might be judged by the EU as adequate or not. To what extent are our protections based on EU involvement in that?
Yeah, that's interesting. I suppose I wonder if the claim, Andrew might want to come on and correct me, but is that the EU essentially sets the floor, and then everyone's required to rise to that level if they want to continue doing business with the EU, whatever it may be. And I think there's some weight in that claim, and I think we'd be better off. It wouldn't be a total solution, but we'd be better off if Australia adopted the GDPR and made that a requirement for all companies in Australia. I mean, we don't, but I think there's a point there that being able to engage with the EU from a commerce perspective, if they have more compliance requirements than us, then our companies will also need to comply. I mean, I think there are some questions around how the design of regulation might favour big players, and there's a whole dispute about this in the EU about whether designing complex privacy regimes for users might in fact favour those who can afford and put resources into compliance. But in some ways, I sort of think that's a problem we can perhaps fix in design, and there's lots of work that can be done. I think that the regulator in this space could also provide models for companies to comply with. But I think it's a fair point that companies, many major companies are now seeking to influence the regulatory tendency and impulse, particularly in the United States, to a lesser degree Europe. They've tried there, but I think they think that they've largely failed, but particularly in the United States. And I think we absolutely need to be wary of technology companies complaining about the potential of regulation only to turn around and then ask to be involved in the drafting of them itself. Mark Zuckerberg's a classic offender in this respect. Talked long and hard about their motivation to move fast and break things, not be particularly interested in the consequences of breaking things, including laws. And then, famously penned an op-ed in the Washington Post talking about the need to regulate his own platform. And that's because he wants to be in the room kind of setting those boundaries. And that's something I think we should be pretty cautious about. But otherwise, to the extent regulation doesn't favour existing participants or large players more so than others, I think that there's real scope for us to adopt some of the things that are coming out of other places rather than wait for our own politicians.
Absolutely, which leads me on to another question which has come through, which is that while technology is generally global, the legal framework often is largely national. And I suppose we'd often think of it in that way in Australia for the reasons that I outlined earlier. We're not part of a broader community such as an EU Court of Human Rights. We don't have, we haven't brought various agreements and treaties into our domestic law. So the enforceability of those treaties is an issue as well. So how do we get around this issue that technology is global, but a legal framework, particularly in Australia, is national?
Yeah, of course. I push back on the presumption there, of course, because Facebook, when it engaged in its news ban across Australia, did so in a pretty geographically specific way. I mean, it was a little blunt, but it was kind of astonishing how accurate they could be in terms of stripping pages of their news content. So they clearly have some way of demarcating these things. And the reason why I raised that, I suppose, or that they're not just simply international behemoths that exist in no place, is that there are some things we can't do about the fact that large tech companies are largely headquartered overseas, but there are some things we can do. So, we can't stop necessarily mergers and acquisitions, but we can say that privacy laws apply in our particular boundaries and that companies are required to comply with them. And I think that we can start to use our muscle a bit more in more nuanced ways, and not just assume the only way to solve the problem of big tech is to break up these platforms or to stop certain kinds of mergers and acquisitions. So there's definitely things we can do within our own jurisdiction, and companies operate in that way too. The other thing I'd kind of mention in this context is, we can do more things in relation to tax. There are other countries that experiment with these kinds of things. One of the big problems with tech companies is they make so much money and they pay so little tax. France, for example, did experiment with a tax on revenue rather than a tax on profit for some of these digital platforms. I mean, it did spark something of a trade war with Donald Trump, so I'm not naive about the potential for this to bring in geopolitical concerns. But I think if we are concerned about the power of big tech, and politicians like to talk about that a lot, one thing we could do is try and compel them to pay more tax rather than just get them to sponsor non-profit activities, which can be too often the substitute for meaningful, taxation and redistribution.
And Lizzie, you're obviously the founder and board member of Digital Rights Watch. One question that's come through is, what is Digital Rights Watch currently working on?
So much stuff. Can I tell you, Carmel? It's a very busy space. And I would encourage anyone who's interested in these topics to check us out and look up what we're working on and the like. So, we've run a lot of different campaigns. One of them is around facial recognition, for example. We are calling for a moratorium on facial recognition. That's not totally unprecedented. I mentioned before some cities that have done it, but the Australian Human Rights Commissioner has also talked about a moratorium until we can develop frameworks around these things. We provide submissions on lots of different legislation. So the inquiry into the Privacy Act, we provided a submission. We also we provided a submission on the proposed Online Safety Act, and looking at some of the concerning expansive powers that will be given to that commissioner, and understanding how we can limit online harms while also providing a transparent and accountable decision-making process for takedowns. So there's lots of different bills that come up over time. I mean, I haven't even mentioned surveillance, which is a perennial, holder of a place on our dance card on a daily basis. There's always legislation that comes in. Australia, I think, is the country with the most national security legislation passed since September 11 in 2001 of any country. So that's a pretty unhappy accolade. So we do our best to try and critique those expansion of those powers as appropriate, and that's a regular bit of work that we engage in. So we are generally, we've got a big project in the next 18 months looking at how we could, kind of what we were talking about before, how we could build an internet that's actually for the Australian community, rather than just imposing Silicon Valley values on Australia by these big tech platforms. And we're going to be talking to content creators, to activists, and to all sorts of people who use digital platforms, and asking them how we could build an internet that actually serves them and helps build strong, robust communities instead of just lining the pockets of billionaires. So that's going to be a long project that we engage in, and we are interested in talking to people about it. So there's so much work to do in this space. And it's really rewarding because you can have great gains. You can talk to politicians in compelling ways. You can also talk to lots of people in different social movements who may not have, these topics may not have occurred to them. So there's huge amounts of work to be done that can have really tangible results. And so I'd encourage anyone who might be interested to check us out and get involved.
Fantastic. That might be a good place for me to wrap up here. I'm mindful of the time. We've had some fantastic comments and questions come through, which I would love to go into in a bit more detail, but I've got an image of someone dragging me off with a large hook. So to do that task, I will hand it over to Marina to perform that duty for me.
Thank you for a lovely presentation. I could listen to you for hours. Certainly a lot of conversation in the chat. So please do go to the YouTube channel and catch up on what you might have missed. Also, to subscribe for your personal invitation to events, you can do so by using that link down the bottom. There are the contact details to subscribe to the Society, to follow Lizzie, and to also reach out to Carmel. I'm sure they would be happy to hear from you. We have a series of masterclasses for lawyers and IT professionals around this area of rules as code, which I think is going to be quite revolutionary in the field of law making, law enforcement, and also all the policy aspects as well are starting to be codified as well. This is into machine understandable language. So an interesting movement, and we're hoping to boost up your skills and understanding of that technology by our masterclass series. So we've already had number 1 and 2. 3 is coming up, and we have others planned as well. So here are the presenters for Masterclass 3. They'll be showcasing the Austlii Datalex platform, and the 3 speakers are there noted on the screen. So that is all from me in terms of announcements. I'll switch off the recording function, and if you'd like to join us in conversation, you're more than welcome. Thank you, Carmel and Lizzie, for staying with us.
I did just want to say thank you so much, Marina, and thanks for Carmel as well for your kind and generous engagement with the book. It's always nice to talk to people about these topics generally, but I'm really honoured and grateful that you put such work into this. It's lovely to be able to talk to audiences about these things that I think are really important. So I'm very grateful.
They are. We're very grateful to you, Lizzie. Thank you. Thank you, Carmel, as well.